I shared my screen a few seconds ago. Can you please ensure that it was visible?
Yes, Code Master, it was visible.
Thank you. I would like to request all the participants to please turn on their cameras.
Hello? Hello? I'm audible? Which time audible?
You are
Yes.
audible, sir.
Yes, sir. Yes, sir.
Okay. I deeply apologize, and I really got into some really issue I couldn't get up. Yeah.
A very good afternoon, everyone. Respected judges, dear participants, and all the attendees. Welcome to the final rounds of the first FICCI-CLC Virtual National Moot Court Competition. I'm Aziz, and I shall be the court master for this courtroom. This courtroom will witness the arguments between IPTC 19 from the side of claimants and IPTC 31 from the side of respondents. Dear judges, please note that earlier I had sent you an email which contained the compendium from the side of IPTC 19 from the side of the claimant. Both the teams will have 40 minutes each. Both the speakers have reserved specific amount of time. There will be 5 minutes available to the claimants as a rebuttal, which should be an extra apart from the 40 minutes which have already been allotted to each of the teams. Please note that the sur rebuttal is on the discretion of the judges. Without further ado, if everybody is well versed, should we begin? Judges, do you have the permission?
Yes.
Please, yeah. Thank you.
Judges, please note that IPTC 15 will first present the arguments from the side of the claimant. Speaker 1 has reserved 22.5 minutes for their arguments.
Am I audible?
Yes.
Greetings to the bench. This is the counsel appearing on behalf of the claimants in the case of Pola Publishing House and others versus Jenny and others. The counsel seeks permission to collectively address the bench as your lordships. Much obliged. The council seeks permission to state the facts. Much obliged. Jenny and Alex, residents of Bluestock, Indiga, are devoted fans of mystery author Agatha Rose, who passed away in June 2024. After her publisher, Polar Publishing House, announced the release of the final book, Lurking in the Dark, the first part of which was pre-released in August 2024, but not in Indiga. Jenny and Alex used AI tools to analyze, preview content, and create speculative conclusions about the book's ending. They published the fan fiction on the Indigan platform WeWrite, incorporating an AI-generated image of Agatha Rose and using AI to mimic her voice for narration. This fan fiction confused readers and negatively impacted the sales of the official pre-release, and also negatively affected Agatha Rose's personality rights while exploiting her voice without authorization. As a result, Polar Publishing House and Agatha Rose's PR team sued Jenny, Alex, and WeWrite in the District Court of Kryptonite, USA, for copyright infringement, violating Agatha Rose's moral and personality rights, and seeking to hold WeWrite liable as an intermediary. In the light of above facts, the councils have 5 major issues present before this honorable court, that are whether the court has appropriate jurisdiction to hear the matter. Second, whether Jenny and Alex commit copyright infringement. Third, whether the defense of fair use and transformative use be taken by Jenny and Alex. Fourth, whether WeWrite be held liable as an intermediary. And lastly, whether the use of AI in mimicking the voice of Agatha Rose has violated her personality rights. The council seeks permission to proceed with the detailed pleadings now. Much obliged. The first issue before this honorable bench is whether the court has appropriate jurisdiction to hear the matter, and the council shall be submitting it in threefold sub-issues. Firstly, the District Court of Kryptonite, USA has jurisdiction based on 2 international law principles, that are objective territoriality and doctrine of ethics. Objective territoriality permits jurisdiction when actions outside the forum state harms its territory, while the doctrine of effects applies to foreign conduct that significantly impacts the forum state, as established in the case of United States versus Aluminium Company of America, referred to in paragraph number 2 of the compendium, paragraph number 2 of the memorial. A state can impose liabilities for conduct beyond its borders if it has material effects within. Jenny and Alex's actions in Indiga substantially harmed US by disrupting pre-sales and reader expectations, impacting Polar Publishing and Agatha Rose's legacy. Secondly, the court has personal jurisdiction over the respondent. The court shall be submitting the sub-issue in 2 parts. A, the respondent is subjected to personal jurisdiction based on minimum contacts and purposeful availment. In the case of Burger King Corporation versus Rutskewitz, referred to in paragraph number 9 of the memorial, the court held that purposeful availment occurs when a respondent directs its activities towards the forum state. Additionally, personal jurisdiction over the respondent is established based on minimum contacts principle from the case of R versus Tubman GBH, as referred to in the memorial. This principle allowed non-resident respondent to be subjected to a forum's jurisdiction if they have sufficient contacts. The respondent's activity on WeWrite platform meets this standard, ensuring fair play and substantial justice. B, the court has long-arm jurisdiction over the respondent. This court has long-arm jurisdiction over the respondent based on passive personality principle, which allows a state to assert jurisdiction over the foreign citizen whose actions violate its rights. In Dow Jones versus Gutnick, as mentioned in paragraph number 13 of the memorial, the court ruled that jurisdiction applies where harm occurs, even if the content is uploaded elsewhere. Similarly, in case of Exversa versus Eupharma Laboratories, as mentioned in paragraph number 15 of the memorial, the court supported jurisdiction based on where the infringement effects are felt. Jenny and Alex's fanfiction harmed Polar Publishing House's business interest in the Kryptonite city of USA, fulfilling this requirement. Lastly, and most importantly, US court's judgment would be enforceable in Indiga. It is submitted that Indian courts are empowered to recognize and enforce foreign judgments under Section 13 of CPC, as mentioned in paragraph number 16 of the memorial and mentioned under page number 22 of the compendium, even if the country of origin is not a reciprocating country. While the United States is not a reciprocating territory under Indian law, judgments from non-reciprocating country can still be enforced in Indiga if they meet certain conditions that include compliance with the principles of natural justice, procedural fairness, and that the judgment is issued by a competent court. If your lordship do not have any concern with the present issue, the council would like to proceed with the second issue.
Council, can you throw light on this, the concept of minimum contracts, which you have highlighted in the international issue, and how far it is binding on us?
Indeed, your lordship. Minimum contact theory established in the case of R versus Tobin BGS allows when a non-resident respondent is subjected to a forum's jurisdiction if the effects of the infringement are felt in the forum's state. Like in this case, the effects of infringement, even if the infringement was taken in Indiga, but US Polar Publishing House felt effect in the US by disrupting the pre-sales of Agatha Rose. The effects were felt elsewhere. These are the effects that we are talking about in the minimum contacts theory, minimum effects theory.
Okay, so is any empirical aspect which made you feel that that is affecting your business, or is it only in your US you felt that there is a effect of that?
Indeed, your lordship, our business has felt disastrous effects. Our pre-sales are disrupted by the launch of fan fiction on Indian platform of WeWrite. We are not able to sell as much as we could if the fan fiction was not published. Much obliged. The council seeks permission to proceed with the second issue at hand. Much obliged. The second issue before this honorable bench is whether Jenny and Alex commit copyright infringement. And the council shall be submitting it in fourfold sub-issues. Firstly, Agatha Rose's work is original and protected under copyright law. The council shall be submitting in two parts. A, it is submitted that Agatha Rose's novel, Lurking in the Dark, is protected under copyright law due to its originality. Doctrine of modicum of creativity as established in the case of Landbrook Limited versus William Hill, as mentioned in paragraph number 20 of the memorial, supports this argument. B, claimant's ownership of copyright and lack of registration requirement. It is respectfully submitted that copyright is automatically granted upon the creation of a work. This principle is established by the Berne Convention and reaffirmed by the TRIPS Agreement as mentioned in paragraph number 22 of the memorial, emphasizing that registration is not a prerequisite for copyright protection. The claimants assert that absence of registration does not diminish Agatha's right as the original creator. Jenny and Alex's action are a violation of her right. Secondly, Jenny and Alex have substantially reproduced the work of Agatha Rose. The council shall be submitting it in two parts. A, the claimants argue that Jenny and Alex infringed Agatha Rose's reproduction rights by using a copyrighted material. This is proved by, first, the respondents had access to Agatha's work via read book for free and an online session. Second, their function is substantially similar in plot and character, mirroring Agatha's narrative style and themes. Under the case of Cavalier versus Random House, as mentioned in paragraph number 25 of the memorial and page number 25 of the compendium, both extrinsic, that is objective, and intrinsic, that is subjective tests support the claim that Jenny and Alex's work closely resembles Agatha's original. B, Jenny and Alex's fan fiction is not a transformative work. The claimants argue the court to apply the US Supreme Court's definition of transformative work from the case of Campbell versus Acuff Rose Music Incorporation, as mentioned in paragraph number 27 of the memorial, which requires adding new meaning or expression to the original. Jenny and Alex's fan fiction fails this test as it follows Agatha's original storyline and only uses AI to create alternative endings without changing the work's essence. Thirdly, Jenny and Alex's fanfiction has caused confusion and deception in the market. The claimants submit that in the case of Warner Bros. Entertainment Incorporation versus RDR Books, as mentioned in paragraph number 36 of the memorial, it establishes that fanfiction created for commercial gain can infringe upon the author's copyright. Jenny and Alex's fanfiction stands to impact the market for Agatha Rose's final book, undermining her creative rights. Lastly, and very importantly, infringement of moral rights is in this unauthorized fanfiction created by Jenny, Alex, and B. Right. The council shall be submitting the sub-issue in 3 parts. A. It is stated that the Berne Convention, as it stated in the Berne Convention, ratified by the US, that influences copyright principles by recognizing moral rights designed to protect an author's honor and reputation. Jenny and Alex's fanfiction breaches Agatha Rose's moral rights by potentially prejudicing her reputation and artistic integrity. B. The fanfiction is a violation of right of attribution and paternity. The claimants argue that right of paternity ensures an author is credited for their work, including adaptations. Jenny and Alex's fanfiction violates Agatha Rose's right of attribution by using her work without permission and failing to credit her, misleading readers and undermining her authorship, potentially harming her reputation. C. Breach of right of integrity. It is stated that the right of integrity allows authors to prevent alterations that harm their work or reputation. The claimants argue that Jenny and Alex's fanfiction violates this right by modifying Agatha Rose's original narrative and characters, risking distortion and presenting misleading endings that could damage integrity of Rose's work and her reputation. If your lordships do not have any concerns with the present issue, the council would like to proceed with the third issue.
Just a little concern with that. With respect to there is no plagiarism. Okay, they have just used the work and they read it from the free website and they have used their own means to, to create that. So how can you say that it has been infringed? So as a reader, since I'm a reader, so won't I have my own imagination? And if it is matches, and they have given a disclaimer also that they are not having any commercial rights. Okay, so they have given. So how would you like to say?
Indeed, your lordship. I would. There's a part of this that will answer your question in the third issue, but also the intent or the disclaimer does not matter if there is unauthorized use. They have used, and also there's substantial similarity. Like if the council wants to create a derivative work, then the council can create it with some sort of creativity, with different characters, with different storylines. But Jenny and Alex used AI just to create a speculative ending. They have used this.
So again, it is a speculative only, right? It is speculative, and we cannot. There is nothing to prove that it has violated the moral rights of the author, right?
Indeed, your lordship.
And now the work is taken up by the publishers. That is again the commercial value. So can't the readers have any kind of right in that regard to protect them?
Indeed, your lordship, but they've used Agatha Rose's work substantially. For example, they've used the same characters. They have continued with the same storyline. The only difference that they have created is they have just created the new ending, but the rest of the part remains the same. That is violation of copyright of Agatha Rose's. And also, readers may be confused or maybe decepted by the fact that Jenny and Alex have used Agatha Rose's voice and Agatha Rose's photo as a cover page. They may be them. It may cause some sort of confusion in the market. That is a violation of Agatha Rose's copyright.
The readers are aware. Sorry, wait. You're not audible, sorry.
No, please continue. I'm saying.
I'm saying readers are aware that she's already there, right? So it is only expanding her readership. She's getting more known indirectly because of this. So she's not losing out. In fact, she's getting more readers to reach the original works also because of this. And they were fans. They were fans trying to expand the readership in that sense. So and for the moral rights, the rights would also be from the legal heirs. Are they also a party to this?
Indeed, Your Lordship. Your Lordship, even though Agatha Rose is dead, but still, as mentioned in the facts of the proposition, her last part, the continuation of the series or the last part of the series was yet to be published, and she wrote that part before she was dead. And Polar Publishing House, her legal representative in this case, is yet to publish it. So even if she is dead, she has her copyright. And also we'll be dealing with the issue of how personality rights are transferable posthumously, and the part of legal representatives, we are not aware of whether she had legal hires or not, but as Polar Publishing House is her legal estate, we are assuming that they are her legal representatives in this case. Much obliged. The council would like to proceed with the third issue before this honorable bench. Much obliged. The third issue is whether Jenny and Alex can claim the defense of fair use and transformative work. And the council shall be submitting it in threefold sub-issues. Firstly, purpose and character of use makes them ineligible to claim for the defense. The council shall be submitting the sub-issue in three parts. A, lack of sufficient transformation by Jenny and Alex. In case of Andy Warhol Foundation versus Goldsmith, as mentioned in paragraph number 46 of the memorial, the court ruled that works are not transformative if they're too similar to the original. Jenny and Alex's fan fiction alters only the ending without changing the essence of the original work. In case of Barbara Taylor Bradford versus Sahara Media, as mentioned in the paragraph number 49 of the memorial, infringement was found when a derivative work replicated original elements without significant changes, similar to Jenny and Alex's AI-generated fan fiction. B, lack of malified intent does not exclude copyright infringement. In the case of Saregama India Limited versus Alkesh Gupta and Tips Industries Limited versus Wink Limited, as mentioned in paragraph number 52 and 55 of the memorial, the courts ruled that unauthorized use is the primary issue in copyright cases, not the intent behind it. The claimants contend that disclaimers or a lack of commercial motive do not absolve Jenny and Alex from their liability. C, commercial use undermines fair use defense. The claimants submit that Jenny and Alex's fan fiction was published on VRite, a commercial platform which impacts fair use analysis, as seen in the cases of Saregama India Limited versus Alkesh Gupta, in the case of Andy Warhol Foundation versus Goldsmith, and in the case of Tips Industries Limited versus Wink Limited. Distributing copyrighted material on a commercial platform absolves the defense of fair use. Secondly, Jenny and Alex have made substantial use of protected elements in the fan fiction. The council shall be submitting the sub-issue in two parts. A, respondents' work copied characters, storylines, and etc. As established in the case of Campbell versus Akaf Rose Music Limited, copying of creative elements such as characters and storylines infringes copyright. Jenny and Alex, by adding speculative endings, fail to transform the core elements of Agatha's work, rendering their fan fiction non-transformative. Thirdly, effect on market makes them ineligible to claim for defense. The council shall be submitting the sub-issue in two parts. A, the claimants submit that in the case of Sony Corporation of America versus Universal City Studios, as mentioned in paragraph number 61 of the memorial, works that negatively impact the market for the original work are likely to be deemed infringing. Jenny and Alex's fan fiction significantly harms the market for Agatha Rose's original novel, which directly weighs against the claim of the fair use. B. The work harms claimants' market for derivative works in the future. Claimants respectfully submit that Section 106 of the US copyright law, as mentioned in the compendium, grants exclusive right to create derivative works to the copyright holder. Jenny and Alex's unauthorized use of Agatha Rose's character, plot lines, and speculative AI endings infringe upon AI Agatha's intellectual property rights. It is urged that the Berne Convention and the TRIPS Agreement protect copyright holders' ability to control their works' commercial exploitation. In this case, Jenny and Alex's fan fiction interferes with Agatha Rose's future ability to capitalize on her story and derivative works. Also, core elements of original work are copied by Jenny and Alex. In the case of Hubbard versus Vosper, as mentioned in paragraph number 59 of the memorial, significant copying was ruled against the fair use. Jenny and Alex fan fiction copies substantial part of Agatha Rose's original work, including speculative plot points that closely mirror her work. If the councils are satisfied with the pleadings of the first, second, and third issue, my co-counsel would like to continue for the fourth and fifth issue. Much obliged.
Am I audible?
Yes.
If your lordships are satisfied with the pleadings presented by my co-counsel, the council would like to proceed with the fourth issue.
Proceed.
Much obliged. The fourth issue is whether we right be held liable as an intermediary. The council shall be submitting this issue in threefold sub-issues. Firstly, citing the case of Format Education versus Sorting Hat Technologies Private Limited, mentioned in para 6 of the memorial, it was established that intermediaries lose safe harbor protection when they fail to act on notice of infringing content. We write had the knowledge of Jenny and Alex's infringing fan fiction, but continued to host it, breaching their duty as a passive intermediary. In the case of Religious Technology Center versus Netcom, contributory liability arises when intermediaries provide tools enabling copyright infringement. We write, hosted the fan fiction and provided AI voice simulator to mimic Agatha Rose's voice, disqualifying it from the passive intermediary protection, as has also been highlighted in the case of MySpace Incorporation versus Supercassettes Industry. This case has been mentioned in para 68 of the memorial. Also, citing the case of Performing Rights Society versus Cyril Theological Syndicate, mentioned in para 71 of the memorial, it was emphasized that knowledge and control over the content determine intermediary liability. We write's failure to act despite the popularity of the fan fiction indicates constructive knowledge violating the US safe harbor laws. The AI-generated voice narration diverted attention from Agatha Rose's official book release, diluting the market and confusing readers, impacting sales. Also, the unauthorized fan fiction overshadowed Agatha Rose's final book, harming its economic value, with WeWrite contributing by facilitating its distribution. Secondly, under Section 230C of the Communications Decency Act, intermediaries are protected from liability for third-party content only if they remain neutral. We write, failed to take any action, and AI tools that facilitated Jenny and Alex's misuse of Agatha Rose's voice and intellectual property disqualified it from the safe harbor, as was highlighted in the case of Format Education versus Sorting Hat Technologies. They failed to remain a neutral third party by facilitating features like AI voice simulator. WeWrite became an active enabler of the infringement, allowing misuse of Agatha Rose's likeness, voice, and content. WeWrite had actual knowledge of the infringement, but failed to take action even after constructive knowledge from Agatha Rose's estate, further disqualifying it from the safe harbor. Moving on to sub-issue 3, WeWrite did not play the role of a passive intermediary. In the case of Playboy Enterprises versus Fena, as mentioned in para 79 of the memorial, intermediaries were held liable for facilitating infringement. Similarly, WeWrite actively enabled Ginny and Alex's fanfiction by providing AI tools, including Agatha Rose's voice, making the platform complicit in the violation. Also, they failed to comply with the takedown procedures, as mentioned in the case of R.K. Mohammed versus Haji C. Abdullah, mentioned in para 81 of the memorial. The court held that intermediaries must act upon knowledge of infringement. Despite constructive knowledge, WeWrite failed to take down the content, violating its intermediaries' duty. WeWrite's inaction after notice constitutes negligence, disqualifying it from safe harbor protection under both Section 79 of the IT Act as well as Section 230 of the Communications Decency Act. Citing the case of Kunal Kamra versus Union of India, mentioned in para 80 of the memorial, intermediaries were required to remove infringing content upon notice or constructive knowledge of the infringement, further highlighting WeWrite's failure to meet their legal responsibilities. WeWrite's facilitation of tools like AI-generated voice directly contributed to the infringement, negatively impacting Agatha Rose's commercial interests, including her upcoming book sales. This reinforces that WeWrite's contributory liability, as its actions went beyond hosting content and into actively facilitating the misuse of intellectual property. If your lordships are satisfied with the arguments, the council would like to proceed with the fifth issue.
Just hold on. I just tried you see whether the Agatha's voice was available in public platform.
Agatha Rose's voice was not available on any public platform. Agatha Rose.
Okay. So if it is not available, so this is actually we have taken the help from the AI generated. So can we help the AI responsible for the same? And being an intermediary, they have only facilitated. And being the followers or the fan, don't you think that they have the some kind of right they should be provided so that there will be more reach for that authors? Because being an author, the author should be more happy that if they get the platform. And now coming to that AI generation, or we are having the AI, what about the responsibility? How to fix a responsibility in this regard? Throw light some in this regard.
Indeed, your lordship. Firstly, whoever puts prompts into an AI is liable for the generation of that particular content. In this particular case, Jenny and Alex were the ones who put the prompts to create those voice, even though Agatha Rose's voice was not available on any public platform, but she did host book readings of her books, and therefore they used AI to create a voice which was similar to hers, violating her rights. Also, as far as the liability of intermediaries is concerned, intermediaries have some legal duties and responsibilities to make sure that if there is any infringing content on their websites, they make sure, if they have constructed knowledge of the same, they need to make sure that it is removed promptly. Does the council have permission to proceed with the fifth issue? Much obliged. Issue 5 is whether the use of AI in mimicking the voice of Agatha Rose violates her personality rights. The council shall be submitting this in threefold sub-issues. Firstly, voice falls within the ambit of personality rights. Voice is a protected attribute of personality. In the case of ICC Development International versus RV Enterprises, as mentioned in para 83 of the memorial, it was established that personality rights include voice, a key element of public identity. Agatha Rose's voice, central to her persona, was infringed by Jenny and Alex's unauthorized AI mimicry. Citing the case of Amitabh Bachchan versus Rajat Negi, mentioned in para 84 of the memorial, it was recognized that voice is integral to a public figure's persona. With unpermitted use, violating personality rights is not acceptable. Similarly, the AI-generated mimicry of Agatha Rose's voice by the defendants violates her right to control her identity. The use of AI mimic voice impacts public persona. The use of an AI-generated voice impacts Agatha Rose's personality, rights, as well as her public persona. In the case of Hicks versus Casablanca records, mentioned in para 85 of the memorial, the court emphasized that separating fan fiction from real-life figures is important. Jenny and Alex's use of Rose's voice in fan fiction misleads readers, associating her with unauthorized content which tarnishes her reputation. Agatha Rose's moral rights are violated by the unauthorized use of her AI-generated voice. This unauthorized association with speculative content dilutes her posthumous reputation and compromises the integrity of her persona. Moving on to the legal and commercial implications of AI-generated voice imitation. Although Jenny and Alex may not have directly profited from using Agatha Rose's voice, the platform WeWrite did. The commercial context strengthened the arguments of unauthorized exploitation. In the case of Saregama India Limited versus Alkesh Gupta, mentioned in para 87 of the memorial, the court had highlighted that even indirect commercial gains from the unauthorized use of a protected work can violate personality rights. WeWrite had benefited from the increased traffic and user engagement due to fan fiction, and thus it exploited Agatha Rose's voice for commercial gains, compounding the violation of her rights. Moving on to sub-issue 2, posthumous application of personality rights. The council respectfully submits that Jenny and Alex's use of AI-generated imitation of Agatha Rose's voice posthumously violates her personality rights, which remain inheritable and protectable after death. Personality rights, including the right to one's voice, can extend posthumously. In the case of MLK Center for Social Change versus American Heritage Products, mentioned in para 88 of the memorial, the court recognized that a person's voice, image, likeness are inheritable even after death. Protecting the use from unauthorized commercial exploitation. Although Agatha Rose is no longer with us, her estate holds the right to protect her identity, including her voice, from any unpermitted usage. Moral rights such as integrity and attribution continue beyond death. In the case of Manu Bhandari versus Kala Vikas Pictures, mentioned in para 89 of the memorial, the court confirmed that moral rights do not necessarily expire with the death of the author, and her estate retains the right to protect the integrity of her work. The AI mimic voice of Agatha Rose, used without consent, disrespects the integrity of her persona, causing damage to her legacy. The right of publicity is inheritable, as established in the case of estate of Presley versus Russin, where it was established that a property right can be passed on to heirs. Similarly, voice and other rights can also be inheritable after death. By using Agatha Rose's AI-generated voice to narrate speculative fanfiction on a platform, benefiting from the increased traffic, Jenny and Alex have commercially exploited her identity without authorization. This amounts to a clear violation of her estate's right. Posthumous personality rights serve to protect dignity and legacy. Courts have recognized the importance of maintaining the reputation of deceased individuals. While Jenny and Alex's fanfiction may not directly defame Agatha Rose, the unauthorized and distorted use of her voice undermines the legacy she worked to build. This unauthorized AI imitation has the potential to mislead her fans and erode her lasting influence. Lastly, the council stands before you to assert that unauthorized use of Agatha Rose's voice by Jenny and Alex through AI technology constitutes a violation of personality rights, and this misuse amounts to infringement of a right to privacy and personal autonomy. As mentioned before, in the case of Amitabh Bachchan versus Rajat Negi, the court protected Bachchan's voice, name, and image from unauthorized use. Similarly, Jenny and Alex's use of Agatha Rose's voice without authorization exploits her identity and harms her legacy. The unauthorized use of personality rights, as recognized in the case of Barkha Dutt versus Waipo, is unlawful. Jenny and Alex's use of Agatha Rose's AI-generated voice without consent directly violates her personality rights. Privacy was upheld as a fundamental right under Article 21, extending to personal attributes like voice as well. Jenny and Alex's use of Agatha Rose's AI-generated voice without consent infringes his posthumous rights to privacy. In the case of Shivaji Rao Gaikwad versus Varsha Productions, the court ruled that unauthorized use of a celebrity's likeness violates personality rights. Jenny and Alex's use of Agatha Rose's voice is a key part of her persona, making her identifiable and violates those rights. The unauthorized use of Agatha Rose's voice on WeWrite, as argued in the case of Anil Kapoor versus Simply Life India Private Limited, showcases clear commercial exploitation. As WeWrite benefited from the increased readership traffic, Agatha Rose's likeness was commercially exploited for attention and profit without permission, further supporting her argument that her personality rights were violated. Although India lacks legislation on deepfakes, the right to privacy and personality rights under Article 21 and intellectual property provides adequate protection against unauthorized AI-generated content. Jenny and Alex's AI imitation on Agatha Rose's voice is a violation under these protections. If your lordships are satisfied with the arguments of the fifth issue, the council would like to proceed.
I just wanted to check if you mentioned privacy rights. Is it privacy or personality or publicity?
All of them. Privacy rights, as in Agatha Rose has the right to protect her private, her personal personality, like attributes such as voice, actions, etc. Like I mentioned, the case of Anil Kapoor. Anil Kapoor had this had a different personality, and he had the right to protect it in under different cases. He had the right to privacy, right to personality, and also moral rights to protect all these attributes which were specific to him.
So you are saying that posthumously also personal rights should be maintained, protected.
As the court had ruled, we need to protect the integrity of a deceased personality.
Okay, but whether this type of personality, like personality rights, should be protected, and moreover, is it not that it is the publishers, because it is nothing derogatory, or we can say that her fanfare is still increasing. They have not done anything harm to her personality with her voice in that manner. It is only the publishers, and with the commercial right. In a way, there is a conflict with the commercial right of the publishers that make you come here as a claimants, and not we think that it is the Agatha. If she was alive, it would have been a different manner. Don't you think that?
Indeed, your lordship. But however, only the author has the right to edit or derive.
We agree with the authorship, like the copyright, but here when it comes to the personality right with regard to the voice and all, what's your say on that?
Indeed, your lordship, I understand that what Jenny and Alex did not necessarily derogate her personality or in any way harmed her personality. However, a person has the right, publicity rights are derived from privacy rights. A person has the right to maintain his or her integrity and to protect his or her personality rights. Therefore, even though they might not have done any harm to her reputation, but there's a certain legacy that she had built through her books' popularity, and she has the right to attribution and integrity. Therefore, the council submits that even though no harm was done to her reputation, still there was a legacy that she had built through her books, through her narrations, and that is what had been violated here by Jenny and Alex. Does the council have the permission to proceed with the prayer? Wherefore, in the light of facts and arguments presented, the claimant, Polar Publishing House, and the PR team of Agatha Rose respectfully pray before this honorable court for the following reliefs. First, that the honorable court assert its jurisdiction to adjudicate this matter, as the wrongful acts committed by the respondents, Jenny and Alex, have significantly impacted the claimant's commercial interest in intellectual property in Kryptonite, USA. With the permission of your lordships, I would like to seek time extension to state the prayer.
Just seconds.
Much obliged. that the Honorable Court find the respondents liable for copyright infringement as their unauthorized use of creative elements from Agatha Rose's work, including plot lines and characters, violates the exclusive rights of the claimant under the Copyright Act. Also, that the Honorable Court reject the respondent's claim of fair use as the use of AI-generated content is neither transformative nor educational, and the fan fiction directly harms the commercial market for the official release of the third book, Lurking in the Dark series. That the Honorable Court hold WeWrite liable as an intermediary as the platform facilitated and failed to prevent the dissemination of infringing content and profited from the wide circulation of fan fiction and deleted the claimant's original work. That the court grant any other relief that it deems fit and proper in the interest of justice and fairness, all of which is most humbly prayed. It was an honor to plead before this court.
Judges, please note that the respondents will now present their arguments. Both the speakers have reserved 20 minutes each.
Greetings to the bench. Firstly, the council seeks permission to address the bench collectively as your lordships for convenience. Much obliged. My unique identification number is 31, and I am appearing on behalf of the respondents, that is Jenny, Alex, and WeWrite in the present case before this honorable court. I shall take a total of 20 minutes to make my submissions, and my co-counsel will take the remainder. Your lordship, today we stand here to argue in support of Jenny and Alex, who are passionate fans of Miss Agatha Rose and whose creative fan fiction pay homage to her legacy. While the petitioners have characterized these creations as violations, we firmly submit that Jenny and Alex's work falls under the fair use doctrine and does not amount harming her intellectual property rights. Your lordship, your decision in this regard will hold a profound importance as it will set a landmark precedent in the jurisprudence of the copyright laws. With that, if your lordships are clear with the facts, the council seeks permission to begin with the arguments.
Please.
Much obliged, your lordship. Your lordship, before this honorable court, there are 5 issues in dispute. I will take on the first 2 issues, and my co-counsel will take on issues 3, 4, 5. But however, for the sake of clarity, I will just quickly summarize over all the 5 issues. The first issue deals with the jurisdiction. The second issue deals with the copyright infringement. The third issue deals with the exceptions. The fourth issue deals with the secondary liability. And the last issue deals with the personality right. Your lordship, I shall now be going into the first issue, which deals with the jurisdiction of this honorable court. In this regard, the council respectfully submits that the burden of proving the jurisdiction of this honorable court lies on the claimants. But however, the respondents under section 12 subclause B of the Federal Rule of Civil Procedure submit that the District Court of Kryptonite lacks the jurisdiction to adjudicate this very matter. In this regard, the council will make his arguments in 3 major prongs. Firstly being, the District Court of Kryptonite lacks the personal jurisdiction over the respondents. Secondly, the District Court of Kryptonite does not have the subject matter jurisdiction to try this very case. And lastly, Indian courts as per the Berne Convention are the appropriate jurisdiction. Your lordship, I shall now be going into my first prong. In this regard, the council humbly submits that to establish the personal jurisdiction, it is essential to prove that the actions were purposefully directed towards the United States. However, the council submits that there is no deliberate targeting of US consumers. In the present case, Jenny and Alex have uploaded the book in an Indican website from Indica, and any US audience that accessed the respondent's work did so is merely an incidental. And this very point was highlighted in the case of Bridgeport music case, where the court held that incidental contacts with the forum state is insufficient to establish the personal jurisdiction. Moreover, lordship, in this very case, the court also held that mere accessibility of content does not satisfy the requirement of direct or substantial contacts for the exercise of personal jurisdiction. Additionally, the council submits that the stream of commerce doctrine, as held in the case of Love and Care versus the Instamix, is not applicable in the very present case. In that case, the violator was importing the infringed goods into the United States, and there was an element of commerciality. However, your lordships, in the present case, firstly, there is no involvement of physical goods, And secondly, there is no involvement of commerciality. Therefore, your lords, the council humbly submits that the district court of Triponite does not have the personal jurisdiction. Your lordship, I shall now be going into the second prong of my this issue. In this regard, your lordship, before I go into the depths of this argument, the council, with all due respect, submits that the claimants have attempted to misguide this honorable court by contending personal jurisdiction. In this regard, the council submits that in the present case, this very honorable court lacks the subject matter. Therefore, there is no question of personal jurisdiction. As per the framework outlined by the Supreme Court in the case of Morrison and also in the case of Kaibel, the very two elements are in the first element is presumption against extraterritoriality. Your lordship, US laws are presumed not to apply extraterritorially unless the legislature provides a clear indication otherwise. Even the court in the case of Suba Films held that the US copyright laws do not regulate infringing activities outside US borders. Similarly, your lordships, in the case of Los Angeles versus Los Angeles News Services, it was reaffirmed that US copyright laws apply only within US regardless of the foreign connections. In the present case, since all of Jenny and Alex's actions took place entirely in Indica, therefore the council submits that the US copyright law does not apply. The second element which the court in Morrison upheld was that is the domestic application of the statute. Your lordship, the council submits that the second step requires the statute's focus. In the case of Morrison, the Supreme Court emphasized that if the conduct is relevant to the statute's focus and it is occurring in the US, in that case, the application of the US laws is permissible. In the present case, the focus of US copyright law is to protect the author's exclusive right in the United States only. Therefore, your lordship, however, in the present case, Jenny and Alex alleged infringement occurred entirely in Indica, where they used their own creative skills with the help of the AI tools to write their fan fiction and uploaded it on the VWrite, which is again an Indican website. Thus, therefore, my lords, the council submit that in the present case, it fails to meet this very requirement held by the courts in the case of Morrison and also in the case of Kaibel. Your lordships, I shall now be going into my third prong of this first argument. In this regard, the council humbly submits that any alleged copyright infringement must be addressed in the Indican courts as per the principles established by the Berne Convention, because both United States and also the Indica are the signatories of Berne Convention. Your lordships, as per the Berne Convention in the international framework provides for the protection of the literary and the artistic works of all the authors. Therefore, accordingly, if there is any copyright infringement, it remains a territorial matter. That is, if there is any infringement occurring in Indica, only the courts of Indica will have the jurisdiction. And this very rationale was also upheld in the case of Suba Films, where the court held that the necessity of adhering to international framework is necessary, and also held that in case if there is any extraterritorial infringement, in that case, the US copyright laws will not be applied. If the bench has no further questions, the council seeks permission to go on to the next submission, which is the second issue.
I'm sorry, but I think you're going on the premise on some physical goods. You're talking about the Copyright Act and physical goods.
Yes.
But these are not physical goods. These are services or content available online. So how are you able to use that, the physicality goods, the applicability of the cases you refer, these are referring to the goods, and they were not available in the territory, the jurisdiction there. But here the content is available in that territory. So how do you dispute that?
Thank you for the question, my lord. To clarify your question, my lord, in that very case, to apply the rationale, two indicators were held. Firstly, that the physical goods, for the jurisdiction of US courts to apply, two elements have to be satisfied. The first element is that there has to be physical goods which have to come into US. In the present case, there was no involvement of physical goods. It was merely incidental that the US readers were referring to an Indican website, which is again not clarified by the memo. But and secondly, Your Lordship, there was no element of commerciality, which is required by the very test. Therefore, Your Lordship, the council submits that in the present case, both Jenny and Alex do not have commerciality, and moreover, the readers referring to the fan fiction is merely an incidental. There was no direct contact, is what the council submits, Your Lordship.
Because we all agree there are no physical goods. So physical goods are not there. So in this case would have been applicable had the physical goods were there. The applicability of the case would not work because we are talking about content which is available through portals, including VRite. So they had that content available. So the availability of content in the jurisdiction is not disputed, is it?
My lords, if I may answer the question, if I may address
Yes.
a query. So the case was used here to act as an analogy. The intention of the councils are to ensure that there is no involvement of physical goods, and that has been placed. However, when it comes to the digital forum, the dynamics of the entire legal framework differs. Therefore, what needs to be looked at is that the physicality of the product need not be there. Therefore, the claimants contending that this infringement is there in US also, is that contention will not be any good because it is a digital forum. So hence, that's what this case was used as an analogy to say that physicality existence is not there. And so they cannot frame the jurisdiction to be in US by saying that personal jurisdiction exists. When it comes to a digital forum, what needs to be looked at is the character of the site. This site, its IT server is placed in Indica. Its every existence is an Indica. Therefore, the personal jurisdiction cannot be said to be in US. Is our humble contention, my lord.
How will differentiate the case of Ramdev then?
Your lordship?
Ramdev case, I mean, would you be able to distinguish that case particular or?
Your lordship, since the matter is in the jurisdiction of the US as contended by the claimants and before your lordships, the relevance of an Indian case will have no bearing, and hence there is no relevance. So, if your lordship may permit, I may proceed with the
Last point, sorry, the commercial angle. You said there was no commercial angle, but somebody did commercially benefit from the whole episode. So, how do you say there was no commercial angle to that?
My lords, the commerciality angle was merely an incidental. It'll again be an assumption that maybe the VRite has gotten a commercial profit. But however, we cannot say directly that. If your lordship may go to clarification 8, it clearly says that Jenny and Alex do not have any commercial intent. It was merely in case if let's assume that your lordship, if VRite had any commerciality, it was merely an incidental which Jenny, Alex, and VRite never expected of.
Okay.
And lordship, secondly, VRite is a freely accessible forum. There is no subscription fee or an entry fee to upload a user's. So they haven't. So it cannot be arbitrarily presumed that there is a commerciality aspect. And as my co-founder said, it's established that respondents have not made any commercial gain here.
Also,
Thank
my lords,
Even if even if there is no commercial interest, as you are saying, is it not their commercial interest got violated because of that their sales got dipped and they were not able to vote? So is it not their commercial interest has been violated?
My lady, if I may address your query, the commercial aspect here in this case, where the book sale has been dipped, it only correlates to the second novel. What is being contended by the counsel for the respondent is that the third novel that is yet to be published, those sales have not been affected, and that is the only portion which is being disputed in this case. Second novel's sales being dipped are completely coincidence. It's a mere coincidence in this case, and this factual presence cannot be attached upon and made VRite or the respondents liable in this case, my lord. If we may continue with the submissions, I'll pass on the mic to the co-counsel.
Thank you, counsel. Thank you. My lords, I shall now be going into my second issue, which deals with the allegation of the copyright infringement of Miss Agatha's work. My lords, the counsel in this regard humbly submits that the opposing counsel had submitted they had a valid ownership and that the respondents allegedly copied from Agatha's work. However, your lordship, the counsel, to diffuse their arguments, will put forth the arguments in two prongs. Firstly, being that the works of Miss Agatha does not meet the requirement of a copyright protection. Secondly, the fan fiction does not constitute a copying of the original constant elements. And thirdly, Lordship, is that there is that there is no violation of the right to make the derivative work of the claimants. Lordship, I shall now be going into the first prong. Firstly, Lordship, the Council humbly submits that in the case of feast publications, the Supreme Court established that for a work to be original, it must possess a certain level of creativity. In elaboration, a work must reflect the author's independent intellectual effort and not simply involve trivial alterations of the existing work or the facts. In the present case, Your Lordship, Agatha's novel is inspired from the real-life murder case, which shows that there is a lack of modicum of creativity. Secondly, Lordship, the Council submits that the Agatha's writing do not satisfy the idea expression dichotomy necessary for the copyright protection, as defined in the case of Baker versus Selden. In that very case, Your Lordship, the court established that the copyright only protects the expression of an idea, but not the idea itself. In the present case, Your Lordship, Agatha's mystery plotlines, characters, storyline are based on the real-life serial killers. Therefore, the expression of the idea is not distinct and the original. Therefore, Your Lordship, the Council submits that Agatha's work does not meet the requirement of protection of the copyright infringement. Your Lordship, I shall now be going into the second prong. In this regard, the Council humbly submits that the fan fiction does not constitute copying of the original constant elements. In this regard, the Council will make a submission in three main pillars. Firstly, there is a substantial difference. Secondly, the doctrine of merger is applicable. And lastly, the fan fiction is an independent creation. Your Lordship, I will now go into the first element, which is there is substantial difference. Under the ordinary observer test, the courts test whether an ordinary observer, without the knowledge of the nuances of the copyright law, would find the work substantially similar. The courts have emphasized that mere similarities in the genre or themes do not suffice to meet this threshold. The fan fiction authored by Jenny and Alex employs an alternative ending, which is not exclusive and does not overlap with the Agatha Rose books. Moreover, Your Lordship, a disclaimer in the cover page was given that it is merely a fan fiction, and VRight's site is widely known for fan fiction. Therefore, an ordinary observer would recognize the differences in how the story is presented, especially given the respondent's unique take on the characters and the plot progression. Lordship, the second element is doctrine of merger is not applicable. In this regard, the Council submits that when there are limited ways to express an idea, that very expression merges with the idea and becomes unpredictable. In the present case, Agatha's novel is based on a real-life incident, and in the murder mystery genre, there are certain elements such as detective, suspect, and a series of clues are indispensable to telling such a story. All the similarities between the novel and the fan fiction are the very ideas and inseparable expressions. Therefore, Lordships, these similarities are not protectable under the copyright laws. The third element is that the fan fiction is an independent creation. In this regard, the Council submits that the court in the case of Ellis versus Duffy held that the independent creation are protected from the infringement allegations. Your Lordship, in the present case, the respondent created their fan fiction incorporating public and AI-generated information to generate plot ideas only and develop the characters. While they were aware of Agatha's works, the use of AI and their personal creativity led to the creation of the original content. Therefore, Lordships, the work does not replicate Miss Rose's specific expressions, but merely takes the inspiration from the genre. Therefore, it results in an independently crafted narrative. Your Lordship, therefore, all these three elements are satisfied. With that, Your Lordship, I shall now be going into the final leg of my argument. In this regard, the Council submits that under the Copyright Act 1976, for a work to merit derivative protection, it must demonstrate a certain level of originality that is more than trivial or mechanical. And this rationale was also given in the case of L. Batlin and Son. In the present case, Your Lordship, Agatha Rose's original work consists of minimal creation content as it is based on the real-life serial killers and contains generic themes. Additionally, Your Lordship, the council contends that Agatha Rose's work falls under the transformative work and not under the derivative work. Moreover, the court in Campbell case held that the transformative work should add new elements. But Your Lordship, in the present case, Miss Agatha merely merely takes the stories from the stories from the real life incidents. Therefore, the council submits that Miss Agatha's work does not have the right to make a derivative. So, therefore, Your Lordship, there is no violation. If the bench has no further question, the council would like to conclude, and I will pass on the torch to my co-counsel to argue on issues 3, 4, and 5. Much obliged, Lord. Are you ready?
May I be permitted to proceed, Your Lordships? Much obliged. Greetings to Your Lordships. As my co-counselor has submitted, the issues of there being no jurisdiction in US courts and there being no case of copyright infringement is established. Now, with Your Lordship's permission, I will be making arguments relating to other facets of copyright infringements, that is exceptions, secondary liabilities, and violation of personality rights. But preliminarily, with all due respect, Your Lordship, I would like to highlight that the claimants post their contention that the jurisdiction is in US. They have majorly armed their submissions with Indian case laws and statutes. Thereby, they are filling and carrying a bucket of water here to put out a fire in a building across town. So their submissions are unsubstantiated. With bearing this in mind, may I proceed with the legal points, Your Lordships? Much obliged. Under issue 3, the council would like to submit that the exceptions for copyright infringement comes into the picture only when there is a copyright infringement. In the present case, there is no infringement, thus it will be superfluous to argue on the applicability of the exceptions. However, in arguendo, assuming that there is an infringement, Your Lordships, the council most humbly submits that the respondent's fan fiction is also eligible to claim protection under the statutory exceptions outlined in section 107 of Copyright Act, which governs the fair use doctrine. Under the provision, there are 4 prongs. Purpose and character should be transformative. The nature of the original work should be highly creative. The amount of the copyright material used should not be substantial, and it should not be integral aspects. And lastly, the alleged infringing actions, it should not cause any harm to the future markets. With this said, regarding the first prong, Your Lordships, the council submits that the respondent's fan fiction is highly transformative and non-commercial in nature. It is contended to fall within the ambit of fair use doctrine under the exception provision. According to the bench in Campbell, for the applicability of the provision, the new work needs to add new expressions or meanings to the original work. The fan fiction has clearly fulfilled this basic requirement as it contains an entirely different climax. This transforms Agatha Rose's original work by offering a different perspective to it. As in the case of Bill Graham Archives, repurposing a copyrighted material for a new context is protected within the ambits of fair use doctrine. In addition to this, Your Lordships, the fan fiction also does not replace Agatha's writings, but stands as a separate and independent creation, further enhancing its transformative nature, as held in Blank vs. Coons. And lastly, the claimants have conveniently omitted the commercial purpose as mandatorily required under section 107 and misguided the court. The commercial intent should be present for denying the fair use doctrine. If Your Lordship may look at the Moot problem in page 1, para 6, it is clearly mentioned that there is no commercial purpose, and this is a mandatory requirement. Further, the claimants have relied on Indian case laws to interpret and substantiate the argument under the US copyright law. This is not permissible. Therefore, the case is clearly set against them, and the fan fiction is transformative without any commercial purpose. Thus, it is submitted before Your Lordships that the fan fiction significantly differs from the original work. Under the second leg, the council would like to submit that only creative works receive sturdy protections from all copyright infringements. Agatha Rose's work, however, draws heavily from real-life murder crimes, making its creativity thin. Citing Swatch Management and Face publications, the council would like to highlight to Your Lordships that the works based on real events or factual elements receive softened copyright protection. Therefore, as per this legal principle, the protection of Agatha's work is weakened. Secondly, as Campbell noted, this prong holds lesser weightage when the subsequent work is transformative, as argued above. Therefore, for the foregoing reasons, it is submitted that the second element of fair use doctrine also favors the respondents in this case. Now, moving on to the third prong, the council here submits that the use of Agatha's original material in the fan fiction was kept to a minimal. Referring to Warner Bros., the council asserts that the portions of Lurking in the Dark, that is the novel, was used solely to build the foundation of the fan fiction. It wasn't, intention was not to copy the entire work. The material taken was minor, it was publicly available, and did not compromise the core Agatha's novels as given in Harper and Row. Therefore, your lordships, the use of Agatha's material was not substantial in nature. And lastly, pertinent to the fourth prong, the council's contention is that the fan fiction does not interfere with the market of the copyrighted material. As established in Campbell, the fan fiction provides a distinct and different experience that does not reduce the demand for Rose's novels. The existence of the fan fiction work also does not inherently harm the original work's market, as pronounced in case of Twin Peaks. Therefore, it is submitted that the fan fiction is protected by the fair and fair use doctrine under the copyright laws, and there is no valid claim against the respondents for the infringement of any copyright. If your lordship is satisfied with this, I may proceed with the next submission. May I proceed?
You've referred, I mean, they can't refer to the Indian cases, but the cases you've referred to, most of them are of the last century, you know. So any current case law on the points you've listed, I think 2006 or 92, 82, when we didn't have AI or even the internet for that matter. So the applicability of that cases would have changed because the whole the ecosystem has changed to an extent.
Your lords, to address your query, thank you for the question. To address your query, the copyright law, it's an archaic law and it's been followed for centuries in US. And second, what needs to be looked at here is the modus operandi of integrating technology and law, and that is being happening for centuries. Be it the COVID time online forums, as the current bench is engaging in. All these are new technologies that is slowly being integrated to the existing provisions and to the settled law. So these laws are settled. These case laws have settled the law, and the new technology, that is AI, which is very recent, is also will be integrating and will be smoothened and will be in sync with the established principles of legal principles. And so there won't be any discrepancy or any change of law. And also these provisions these case laws are not overruled, your lordship. So they are still legally valid. Much obliged. May I proceed to the next issue? Much obliged. So if I may proceed to the fourth issue, your lordships, I contend that V-right is also not secondary liable as an indirect infringer. To support this submission, I would like to bring the court's attention to the lack of grounds for attaching secondary liability. The claimants have contended that there is contributory infringement. However, my learned friend has erred in making such conclusion. With your lordship's permission, I will now prove that there is no contributory infringement and further reiterate the point by proving the lack of grounds under the other two components of secondary liability as well. There are three grounds for which secondary liabilities can be extended. One is contributory infringement. Second, vicarious infringement. Third is inducement infringement. I will now strike down each and every infringement. Coming to the contributory infringement, your lordships, it requires knowledge and material contribution as established in A&M records case. In the given case, V-right is a neutral platform and lacks oversight over the user uploads. The platform cannot be assumed to have knowledge and all the uploads because of the impossibility test, and the amassing inflow of content with no supervision clearly highlights the lack of specific knowledge of the fan fiction. The same is also not notified to the site by the rightful owners or the concerned parties. Hence, it cannot be presumed to have knowledge of the copyright violation, and imputing such knowledge is also unreasonable. In line with this, with no knowledge, the requirement of material contribution is not met. Therefore, it is contended that V-right cannot be held liable for contributory infringement. And secondly, coming to vicarious infringement, alternatively, as defined in Metro Goldwyn case, there should be financial gain while having control over the website. V-right does not profit directly from the fan fiction, and it provides a free platform without any commercial purpose. Additionally, the platform, as in the clarification point 8, the platform has no control over the uploads. Therefore, since there is no financial benefit or control, V-right cannot be held liable for vicarious infringement as well. And lastly, under the inducement infringement, as again held in the Metro Goldwyn case, the V-right did not promote any infringing activity. Only when it promotes this use of these infringing activities, it falls under inducement infringement. In the present case, it was not a result of the site's promotion or marketing. it was just by user-driven promotion. Therefore, there is no valid claim for inducement infringement as well. In conclusion, none of the elements of secondary liabilities are met, your lordships, and thus VRED is not secondary liable. And lastly, an additional supplementary argument is that in arguendo, even if it's assumed that VRED is indirectly infringing the copyright of Agatha, the site will be eligible to seek protection under the safe harbor provision under section 512C of DMCA, that is Digital Millennium Copyrights Act, and not liable for copyright infringement. And the reason for the claimants have argued that the infringing article is not taken down promptly. However, there is a requirement of the claimants, or at least the Agatha's rightful owners of her copyrights, to notify the site for such takedown. They have not notified, and it cannot be, owners cannot be on the site to choose which article is infringing and remove it on their own volition. So with this, issue 4 comes to a conclusion, your lordships. If your lordships may permit me, I may proceed to the last submission. Much obliged. Going to the 5th submission, once again, they heavily relied on Indian case laws. Regardless, to counter their arguments, I submit that the personality rights of Agatha is not violated by the respondents. The claim of infringement of personality rights also referred to as publicity rights. Both are same. Publicity and personality are same. It lacks merits as it is preliminary contended that the right expires along with the person. The publicity rights, it originated from the concept of privacy rights as recognized in the Hale Laboratories case. Therefore, similar to the right of privacy perishing with the individual as ruled in Melvin versus Reid, the publicity rights also perishes. Thus, without the head, the body cannot remain alive, your lordships. With this, it is contended that late Agatha Rose, the author, is not protected by any personality rights. Nonetheless, with the assumption that the protection still extends to Agatha Rose, as per the legal principle set down in Robertson versus Rochester and Midler versus Ford, there are 2 prongs to prove personality rights. 1, there should be unauthorized use. 2nd, there should be a commercial purpose. It is submitted before your lordship that the 2 elements of personality rights are not met. As given from the facts, there is an instance of Agatha's persona being used, her image, her voice. However, it is also given in the same facts that the AI generation of voice was not for commercial purpose. The claimants also have argued and made a statement have not made a statement regarding the commercial purpose. They have merely stated that there should be an unauthorized use with a commercial purpose, but they haven't substantiated the argument, and they have failed. The mere conclusion cannot be its own reasoning, your lordships. The commercial purpose must definitely be present. Therefore, only one aspect is satisfied, and thus there is no base to hold the respondents liable for infringing Agatha's personality rights. And additionally, along with this commercial intent, there should also be the concept of identifiability. For a violation of personality rights to occur, the trait must be identifiable in the public forum. In Zakini versus Scripps, the US Supreme Court ruled that the unauthorized use of a trait is actionable only if it is directly tied to the individual's recognized public persona that carries certain commercial value. The claimants themselves considered that the voice is not known to the public, and the voice is not known. So in the present case, Agatha's public persona is closely associated only to her literary works and not to her vocal traits. Therefore, AI-generated use of her voice does not diminish the commercial value of her persona at all. Thus, it is submitted that there is no violation of personality rights as well, your lordship. Your lordships are satisfied with my submissions. I may proceed to the last leg of my argument, that is prayer. Much obliged. Wherefore, in the light of the issues raised, arguments advanced, authorities cited, the claimants humbly pray and implore before this honorable district court that this court does not have the appropriate jurisdiction to hear the matter. Jenny and Alex have not committed a copyright infringement. The defense of fair use and transformative work is applicable in this case. Fourthly, VRED is not liable as an intermediary. And last, the AI generation of Agatha's voice is not violative of her personality rights. And pass any order the court may deem fit in the interest of justice, equity, and good conscience. With this, the council concludes the submissions. It was an honor to argue before your lordships.
The claimants now have 5 minutes for their rebuttals.
The council seeks permission to continue to present the rebuttals. Much obliged. So firstly, the council would like to drag attention of the bench to the fact that it was clearly provided in the clarification number 4 that I would like to read the clarification number 4 for all of you. Participants are reminded that the point of contention is whether the suit filed in the US is enforceable in India. My learned counsels have missed the whole point of enforceability. The point was not whether it can be filed in USA or not. It was the suit is filed in USA. Is it enforceable in India or not? Also, they filed the jurisdiction applied to file this case to this honorable bench is via federal rules of civil procedure, whereas it was specifically stated in clarification number 2 that participants are directed to follow the US copyright law. So I urge this court to set aside the jurisdiction of our learned counsel. Also, they've stated that Agatha Rose's fan fiction is not copyrightable. They do not have they don't own the copyright. The councils also say that their work is inspired by Agatha Rose's work. So it is a creative work, and the principle of modicum of creativity applies to them. Similarly, the modicum of creativity applies to Agatha Rose. Agatha Rose, the stories are inspired by real life incidents. They are not based on them. Agatha Rose is inspired through them, and then she writes her own novels. And also, as stated by my learned counsel, that Jenny and Alex's works are transformative and they're creative. They are inspirational. How? Same plot, same storyline, same characters, just different endings. How is this inspiration? This is substantial copying, and I would like honorable judges, I would refer paragraph number 25, 27, and 61. I would like to read them out. It is stated, the extrinsic, that is objective, and intrinsic, that is subjective tests for some substantial similarity as mentioned in Cavalier versus Random House Incorporation. Jenny's and Alex's fan fiction shows notable similarities to Agatha's works and plots. Also, US Supreme Court defines a transformative work that as the one that adds new meanings. But there is no new meaning. There is just a different ending. The meaning remains the same. Now, my co-counsel would like to continue with the rebuttals.
Adding to what my co-counsel said, my learned counsels mentioned that we write as an intermediary did not have knowledge that such a content was being hosted by their site. However, there is a concept known as constructive knowledge, which means that you need to infer from the situation that WeWrite is capable enough to see that there is increased traffic on their site. WeWrite can see that the particular fan fiction is gaining popularity. A lot of people are recognizing it. It is overshadowing the original work, and suddenly there is an increase in traffic in the site. So I think through ordinary prudence, WeWrite could have known that such a thing was going on their website, and they are liable as an intermediary, because intermediaries have the legal duty to ensure that the content posted on their sites does not violate anyone's right. Also, as far as the concern, as far as the disclaimer is concerned, I would like to refer para 52 of the memorial, which says that intent is not a defense against copyright infringement. In the case of Tips Industries versus Wink Limited, the courts have clearly ruled that the focus is on unauthorized use, not on intent. Doesn't matter whether disclaimer was given or not given, how was it given. What matters is that their fan fiction, regardless of its creative purpose, used copyrighted material without permission, constituting infringement under the Indian law. That's all from my side.
Your Lordship, if we may counter their rebuttals. So firstly, with all due respect, what my learned counsels have done is that instead of rebutting our arguments, they have summarized their own arguments again, firstly. And second of all, they have said that they have referred to the clarification and said that they should check whether under the fourth point, whether the US laws are enforceable in Indiga. That's a jurisdictional questions, and we have sufficiently argued regarding the same. If you come to the second point, the same clarification, it clearly says that participants are directed to follow the US copyright law. So they cannot use the Indian copyright law. This is our second point. And thirdly, the copyright, my co-counselor will take on the next point.
Yes, my lord. Also, my lord, the councils have blatantly told that we have used the Indian copyright law, but however, the council submits that we have used the copyright law of 1976. We have not used the Indian law, which is Copyright Act 1957. We have used the Act of 1976. My co-counsel will add two more points.
And one more last point, that they've said that knowledge can be imputed. Knowledge can be imputed, and the website should remove the infringing article on their own volition. The reason, the legal question whether there is any infringement or not is before this lordship, and your lordship must decide that there's an infringement. Only then website can remove it. Website cannot arbitrarily assume that they are the adjudicating authority and order that this particular material is infringing, and they cannot pass an own order and remove it on their own on those grounds. The matter is unknown whether the material is infringing or not, and hence it has come before your lordships. So it cannot be upon the website to decide and remove the material because it's infringing. First point. Second, the onus is upon the owners to notify the site of such infringement, and both are not in this case, your lordship, and hence on the claimant. Sorry, I misused the word. The claim is onus on the claimants to notify the respondents. However, it is not the case, and this concludes our rebuttals, your lordship.
Thank you, lordship.
Much obliged.
Now that the parties have ended with the arguments, I would like to request everybody present, please turn on their cameras for a group picture. Thank you. I request the judges to please join the alternative link for the discussion for scoring. Participants in the meanwhile can wait.
Yes, court master.
Okay, from my side, am I audible? Yes. See, both the teams have done very excellently, or they have performed very well. And this is a very upcoming area with respect to the AI and all. And, you try to use the authorities that are available to your best and try to put your arguments from both the sides. Like, both the claimants and the respondents tried their best. And but what I would like to say is, it's like certain aspects which I have noticed. Maybe it is the virtual mode. So it's a virtual mode. So one thing is that when it comes to the claimants, when they were arguing, they were in a very calm, composed, and they were very much with that appearance. And as far as the respondents concerned, both of you are like, sometimes maybe I felt like that, very agitative. And but one aspect of the respondents I would like to credit is both of you worked in a team, like supporting each other. That's the best part. I appreciate for that. Okay. And others, they were not having that team. Maybe they are not required that, but this is one perspective. And when it comes to the authorities or that you have referred, it will be always, because whether if any of the recent case laws or any of the articles in that matter, because those who are doing the research in this AI and all, so any kind of authorities or articles in that matter, maybe from the academic perspective I'm saying this, so that can also be referred. So then it would have been more engaging. But both of you have done excellently well. It was very difficult to judge. So all the best. both the teams.
Thank you very much.
Yeah, thank you so much. I think you covered it pretty well that, both the teams were very good, very vocal and calm at the same time. The girls were really calm. So, yeah, calmness is also important in a court, to keep your cool. But at the same time, the education was maybe required at that to really defend that case, which was a little towards the plaintiff side, the claimant side. But very well argued, both sides, very well done. And I think the citation ma'am has already covered that, it's always good to have some recent citations. It's good to start with the older ones, but back up with the recent ones. It's good to know that how law has traversed. And this was the thing which has continued even with the change of technology. So that would help you to do that. And articles would always be there because idea is that we are trying to set some precedents in a court of law. So precedents would not be there. So if we are trying to set up, so academia articles from industry or academia would be helpful to set a precedent. So you'll be there part of a precedent, a watershed case law being decided. So that would really help. So you refer to articles because this is such a new topic and nobody has a grasp on it across the world. People are still debating. A lot of things will still come up, and which is good. And IP and AI would always, there'll be a struggle, tussle. But it's good to see the different arguments and very, very good arguments in the sense of, like she said, it's difficult to go with where it was really good, but everybody was very good. Congratulations.
Thank you, sir.
Thank you, sir. Thank you so much, sir.
Thank you, judges.
Thank you, sir.
Requesting the judges to kindly join through the separate link
Yes.
provided.
Okay.
Thank you.
Thank you.
अब इस लिंक में ज्वाइन करना है ना हमें। हाँ थोड़ा लैग रहता है।
So very
A very warm evening to everyone. I'm Aziz, and as the student convener of the Moot Court Society of Campus Law Center, it gives me immense pleasure to welcome one and all to the valedictory and prize distribution ceremony of the first National FICCI-CLC virtual Moot Court competition. The competition was a joint venture between the Federation of Indian Chambers of Commerce and Industry, FICCI, and the Moot Court Society of Campus Law Center, with SS Rana and Co. as the knowledge partner. Without any further delay, I'd like to request Ruchita Singh ma'am, the Joint Director and Head of FICCI's IPR Division, to deliver the introductory address. Over to you, ma'am.
Thank you, Aziz, for your kind introduction. I hope I am audible and I am visible as well. Good evening, everybody. Esteemed guests, faculty members, participants, and fellow intellectual property minds. Now that we have reached the conclusion of this remarkable event, which is the first national virtual moot competition organized by FICCI IP Cell in collaboration with Campus Law Center, University of Delhi, and our esteemed knowledge partner SS Rana and Company. A special thanks to our esteemed judges. Their insightful questions, thoughtful comments, and constructive feedback have been invaluable. Their presence and guidance has not only challenged our participants to think critically, but has also provided them with invaluable insights into areas where they can further improve legal skills. We are truly grateful for your contributions to this competition. The participants have demonstrated exceptional legal acumen, persuasive arguments, and a profound respect for the law. Their performance have showcased the future of intellectual property law and potential for innovation and growth in this field. As we conclude this event, I would like to extend my heartfelt gratitude to all the participants, judges, faculty members, and organizers who have contributed to this success. Your dedication, hard work, and support has made this competition a memorable experience indeed. Dr. Alka Chawla, Professor in charge at Campus Law Center, Faculty of Law, University of Delhi, is unable to join us due to a pressing concurrent engagement. However, we are greatly honored to welcome the acting PIC, Professor Dr. Gunjan Gupta, whose invaluable insights and guidance have played a pivotal role in shaping the legal landscape. I now extend the floor to Dr. Gupta.
I think Gunjan ma'am is having some technical issue. She'll just join again.
But there seems to be a connectivity problem. Can let us wait for a short while. Ma'am, you are muted. No, ma'am.
Hello. Am I audible now?
You are audible, ma'am, but the voice is echoing.
Yeah, I have to switch off. I was connecting to my cell phone because the computer had it. Yes, good evening, everyone. What's the reason the voice is echoing?
Ma'am, you could consider switching off your mic on either the laptop or the mobile.
Am I audible now?
Yes, ma'am, it's very clear now.
I'm extremely sorry for this technical glitch. Good evening, everyone. I really feel sorry for this because we have consumed so much of time in this. So now, esteemed guests, distinguished participants, dear colleagues, and my dear students, it gives me an immense pleasure to address you all to the valedictory ceremony of the first FICCI Campus Law Center Virtual National Moot Court Competition, organized in collaboration with FICCI and with the esteemed knowledge partnership of SS Rana and Company. This event has been an extraordinary journey for all, particularly as it focused on the dynamic aspects of intellectual property rights, especially the laws and doctrines related to copyrights. Over the past 2 days, we have witnessed spirited advocacy on complex issues in copyrights laws, a field that is increasingly crucial in our digital age. The intricate balance between protecting the rights of the creators and ensuring public access to information has been eloquently debated by all the participants. This Moot Court competition has provided a unique opportunity for you to not only explore the nuances of intellectual property law, but also to develop the skills essentially to becoming a successful lawyer. The quality of the arguments, the depth of research, and the clarity of presentations were truly remarkable. I congratulate whosoever the winners announced would be for their outstanding performance. But I must also commend every team for their dedication, hard work, and intellectual rigor. Mooting, particularly in a specialized field like copyrights law, requires not only just knowledge, but also the creativity and the ability to think on your feet. Skills that all of you have actually demonstrated in this Moot Court competition. I would also like to extend my sincere gratitude to the esteemed judges who have shared their wisdom and expertise with us. Thanks also needs to be the FICCI for partnering with us to make this event possible. SS Rana and Company also deserves a big thank for their invaluable support as our knowledge partners. The collective efforts have really made this competition a grand success. I appreciate the efforts of the organizing team led by the convener, none other than Dr. Suman Yadav, and the other faculty members of this Moot Court Society and the students who worked tirelessly behind the scenes. Your efforts have really been crucial in ensuring the smooth running of this event. I really thank you for your commitment and dedication. A huge round of applause for all of you. As we bring this competition to a close, I urge all of you to continue exploring the dynamic field of intellectual property rights, particularly as we navigate a world that is increasingly shaped by technological innovations and creative industries. The knowledge and the skills have gained here will undoubtedly serve you well in your future legal career. Thank you once again for your participation and contribution, and I wish you all a great success in your endeavors and look forward to seeing your continued growth in legal profession. And in the end, again, I would really feel a sorry figure that due to the technical glitch, I could not join at the right time. But thank you. Ultimately, we were successful. Thank you.
Thank you, ma'am, for your encouraging words. Now, moving on to the most anticipated part of this ceremony, I would like to request Dr. Suman Yadav, the teacher convener of the Moot Court Society of Campus Law Center, to announce the winners and victors in various categories of the competition. Over to you, ma'am.
Thank you, Aziz. A very good evening to one and all present here. So after going through 2 days of rigorous exercise, finally we reached to the moment for which we all have been waiting. I'm sure you all have enjoyed and had an enriching experience through this comprehensive exercise. So here I go with the results for the first virtual moot court competition organized by Campus Law Center in collaboration with FICCI. So the best speaker for this moot is Ms. Sana Dhawan, IPTC 17, Symbiosis Law School, Noida. Congratulations to Sana Dhawan.
Great.
And the best memorial goes to the team IPTC 31, OP Jindal Global Law University. So many congratulations to the best memorial team. And here we go with the winner. So again, the winner is IPTC 31, OP Jindal Global Law School University. Many congratulations. So runner-up is IPTC 19, Dharmsastra National Law University, Jabalpur. So many congratulations to each and every one, those who are winners and those who participated in the event. Over to you, Aziz.
It's always such a difficult task to conclude with the vote of thanks after the announcement of prizes. But trying to keep the flow of the event. It was first of all a great honor to be a part of the event and being in the organizing team. I would like to extend my heartfelt gratitude to Professor Dr. Alka Chawla ma'am, the professor in charge of Campus Law Center, Faculty of Law, University of Delhi. Professor Dr. Gunjan Gupta ma'am, the acting professor in charge, Campus Law Center, University of Delhi. Dr. Suman Yadav ma'am, the teacher convener of the Moot Court Society. From the side of FICCI, Director General of FICCI, Mrs. Jyoti Vij, Deputy Secretary General of FICCI, Mrs. Leena Jasani, Chair of the FICCI IPR Committee, Mr. Anil Rajput, the Co-Chair of FICCI IPR Committee, Mr. Amit Datta, the Joint Director and Head of IPR Division, Mrs. Ruchita Singh. I'd also like to thank SS Rana and Company for being the esteemed knowledge partners of the event. I'd like to thank all the judges who have taken out their valuable time in agreeing to judge this moot court competition. I'm sure all the feedbacks that the participants have received from the judges would enrich the legal careers of all those who have participated. I would like to thank the executive body of the Moot Court Society and all its members for their tireless effort in organizing this moot court competition. I'd like to thank Ms. Ananya, who was the point of contact between FICCI and the Moot Court Society and who has tirelessly coordinated the event beautifully. I'd like to thank the court masters, the 6 court masters for the event, who at a very short notice joined us and helped us conduct the event. Sachin, Sumant, Vyom, Aditya, Priyanshi, and Daksh. Since this is a virtual moot, without thanking the technical team from both the sides, it would be a gross injustice if I don't extend my gratitude to the technical team from both the side of FICCI and Campus Law Center. All the volunteers from the side of FICCI who have been observing and assisting in all the proceedings. And last but not the least, to all the participants who have made this moot competition a grand success. See you in the next edition. Thank you, everyone. Have a great night.
Thank you, everybody.
Thank you.
Thank you.
Thank you.
And congrats, claimants.
Thank you.
I wish to congratulate all the winners.
Yeah, congratulations to all of them and really well done. It was not an easy task to decide, but congratulations. And I'll be happy to offer internships to the winners and the runners up. Do write to us and we'll be happy to see how we can accommodate you this year whenever it is possible. Congratulations. Thank you.
Thank you, sir. Thank you so much, sir.
Thank you so much, sir.
Thank you, ma'am.
Thank you, ma'am.
Okay.